Outstanding, and welcome to this edition of What's Up in Global Law, a collaborative, co-produced version of intellectual property law and also general law for the Global Chamber of the United States, Global Chamber Organization, which has over, I think, 605 chapters last time I checked, and also of Technology Innovation Law, which is my social impact IP law practice and our social impact legal tech venture. We're honored to feature Marcos Garcia Costa today as a patent practitioner to help us address the question of, is the time now for inventing and patenting? And we think we'll have some very helpful information. And just as a preliminary statement, this information will be available to everyone after the event as a deliverable. Want to encourage folks, if unless you're speaking, you want to jump in, please stay on mute. Please actively use the chat to send in questions, because the goal here is to both demonstrate that you have a community of global trade practitioners, business, policy, etc., that want to support you and engage your activities. But we also want to make sure that we're providing information that creates a dialogue, because we find that we learn from each other as we progress. And so, and of course, on the IP side, this is content for the Global Chamber and for the presenters. And we look forward to connecting with you. There's contact information on the back end. With that said, Mila, is there anything you as our lead want to share from your perspective of the Global Chamber as we go through the agenda? And hearing none, I'm going to believe that Mila is either
She's on
occupied
mute.
or she's on mute. Thank you, Stephen. And hi, by the way. So we're going to go through our standard of what's important today. As you know, our model is we actually consult with a number of large language models for the same prompt and look at their responses to get us started on discussion. Then we'll dive into some of the things that are happening with technology, both on the operator side of different agencies that are responsible for registering patents and intellectual property in their individual countries, as well as what it's doing from a market perspective. And that's where perspectives like that of Marcos will be essential to providing discussion with you as audience. Then we'll actually go through some analyses of, what's the basics? Do you have any intellectual property today? Is it patentable? What do you have? Do you want to pursue that? And kind of what's going on globally. And then close with a call to action and open it up for Q&A. Does anyone have any comments before we go to the next slide? I'm going to take the silence as no, just says,
No.
and keep it moving. So we ran our prompt with 5 different versions of large language models. We typically will query Perplexity, Llama, Gemini, ChatGPT, and Claude. And here's a summary of what they thought was important. Artificial intelligence obviously is getting a lot of attention since the statement from OpenAI that one of their models broke out of its sandbox and attacked the infrastructure for another AI provider. But from a regulatory perspective, AI is not a human inventor, which matters to folks who are seeking patents as well as other forms of intellectual property. There seems to be some emerging consensus of the need for humanity to be involved in inventorship and intellectual property. There are some differences on a global basis from Africa and the European Union. And foundationally, the question becomes, is intellectual property in general and patent in particular valuable to your area, your business, and what you're trying to do. And is the market opportunity right? And we're seeing a lot of activity, especially in the healthcare space. So with that said, I'd like to first pause on this slide and ask our guest, Marcos, to briefly introduce yourself, and then we'll go through our agenda. So, Marcos, tell us a bit about your work, please.
Hi, good morning, good afternoon, everybody. My name is Marcos Garcia Costa. I'm an attorney. I'm based here in Arizona. I'm also a patent attorney, and for the last about 30 years of my life, I've been involved on technology, protection of intellectual property, business, contracts, etc. And I've been working on my own as an attorney in for the last 11 years.
Thank you, Marcos, for that. And if I may ask a follow-on, is your practice primarily focused in the US or internationally, or both?
So I am based in the US and I'm licensed in the US for specifically in Arizona for law, American law, basically Arizona law, but also for intellectual property law in the United States. But I also work with international clients that want to protect business, personal assets, intellectual property assets here in the United States. So I help people that want to soft land in the US from a personal or business perspective.
Thank you for that. So, moving forward and taking the approach of, in order to get somewhere, you need to know where you are at the starting point. We wanted to make sure that we're encouraging folks to inventory and periodically update the inventory of intellectual property they have. From our research in working both with policymakers, ecosystems, and also our clients, we found that that's a big opportunity for folks who have lost track of what they already have that meets these definitions of a copyright for creative expression, trademark or service mark for branding, trade secrets, which are things perceived to have value in the marketplace, but you need to take the appropriate measures to keep it a secret. And then, of course, the patent aspect of it. So that is a fundamental encouragement that we've been doing for over 10 years as a law practice and 2 years as a legal tech startup. That is resonating because folks are finding value in looking at their existing inventory once they become aware of intellectual property. But with that backdrop, let's get into the good stuff because patents get a lot of attention. And let's start with asking Marcos, from your perspective, why are patents so prominent in the intellectual property world?
So in the previous page, you mentioned a few of the different pieces of intellectual property, such as the copyrights, trademarks, patents, trade secrets, and there may be a few other ones that have their own little definitions. But I could say patents are the top of the pyramid. They tend to be, you know, a little bit more complicated than most of the other ones, more difficult to get. But at the same time, depending on how you use them and the context of your business, they can give you a boost for your credibility as a business and as a company. They are inventions, so they tend to be associated with, technology. You think of the big ones, GM, Tesla, SpaceX, etc. So all of them probably have a ton of patents, but also they have a ton of other pieces of intellectual property that they protect.
Thank you for that. And I want to amplify that a bit. So I'm going to fall back to the prior slide. Marco's very well explained patents as being at the top of the pile, and I'm going to use a metric of level of effort to obtain them and probably associated cost. there are unregistered forms of copyright, trademark, and trade secret is unregistered for obvious reasons. The level of effort to acquire those at an unregistered level is very low. The bar is low. There's some cost in registration for copyrights, trademarks, and trade secrets, but it's more nominal administrative fees, relatively speaking. And it's also more of a portfolio perspective because they only apply to creative expression for copyrights, brands for trademarks, and then trade secrets perceived to have value in the marketplace. At first impression, you think they would be attractive because copyrights are for the creator's life plus 70 to 95 years, depending on what they're doing. Trademarks can go on perpetually if you take care of them and build equity in those brands. And trade secrets can also go on perpetually as long as you keep them a secret. But copyrights are a public mechanism that requires rigorous examination by a registered government entity. And that public nature, that effort and investment, in my opinion, and from what we're seeing with the audiences we communicate with, that gives it significant value. So we'll move forward. Does anyone have anything else they want to share or a different perspective on
Uh,
that?
Very quickly, Chris, on the other ones that you mentioned, especially trademarks, they can stay forever as long as you keep, well, if it is a common law trademark, basically you're just using it. It is yours as long as you continue using it. If it is registered, you keep the registration as long as you keep paying the maintenance fee every 10 years after a while. Copyrights, they can be, I don't want to put down a specific number because it can change from country to country, but close to 100 years, depending on how you do the calculation. Trade secrets like the Coca-Cola formula, as long as you keep it as a secret, it stays as a secret. Patents expire, and they are territorials. So you may have um, there's an extra level of consideration that goes in there. What countries, and is it worth the time and effort just for the 20-year protection, for example?
Right. Thank you for that expansion. Let's push forward a bit. And we raised the topic of now is a good time to invent and to patent. And we raised it as a question mark. There's so much change occurring. And I'm going to summarize what I see on the slide and take any comments or questions from our audience and from Marcos. We're seeing regulatory bodies, especially in the United States, aggressively implement artificial intelligence and other technologies because they face a backlog in the areas they regulate. And they're trying to meet their policy objectives. And we summarize some of the findings later in the presentation. From a practitioner perspective, that means that there's different aspects of the business process are changing as well. We're also seeing market pressure. Big technology companies and big creative companies are battling it out for the value of the intellectual property portfolios. And we're seeing the same thing in the smaller spaces. And folks are trying to determine how can they use this technology to achieve their goals, competitive advantage, or some other aspiration. And there's a whole question of what's the level for humanity's involvement. And we think that's been tentatively settled, but at least for the United States, but there are ongoing court cases. So in addition to the normal change that the world experiences, we're now receiving a heightened level of additional change and complexity from what we're learning and speaking with our audiences. And that kind of gets us to some quick shares for the team based on the research that we did for this. This is the Global Chamber. So we wanted to look at what are the different agencies doing with technologies, especially with artificial intelligence, and what is the overall impact. We were pleased to find that to some extent, each region, when we looked at North America, South America, Europe, Asia, Africa, and Australia, and we highlighted the lead country in those regions that were creating intellectual property, especially patents. So the summary of this slide is we're seeing activity across the spectrum. And the research that we found seemed to indicate a generally positive response by the markets of those areas, whether they're the US and they're using AI to transition the process. Some mixed responses because the US has a strong concentration of, and North America has a strong concentration of practitioners like Marcos. In South America, where Brazil is taking action that's reducing the dependency. Europe, where they're implementing technologies increasing productivity and claims of 4% or more. Asia, where China has been prolific and just from a number of patents perspective is almost approaching overwhelming the market to some extent. And Africa, where in South Africa, they're pursuing world intellectual property standard-based improvements. And then in Australia, which has a strong regulatory perspective. That sets the stage for the opportunities for practitioners and for pro se inventors and consultants and agents to pursue working with these organizations as they try to get more efficient. The other side of the equation, in addition to operations, was how important are treaties and other mechanisms which are available in key markets to pursue patents if you wanted to do something outside your home market. And I'll summarize this slide pretty briefly. The PCT is the premium treaty that was mentioned throughout all of the research. And so let me pause and ask Marcos. Marcos, do you have a perspective on PCT and its importance to global trade?
Well, the one of the things we mentioned is patents, as well as a few other intellectual property registrations, such as trademarks. They are territorial in nature. So you file in the United States, you only get protection in the United States if you get the patent. The PCT is a way, and I always tell people, is this something that you're going to be um, selling or making? So the a patent gives you certain protections for the making, the selling, the importation, etc. So if you're going to be making any of that in another country, you need to consider getting protection on those places as well. PCT is one of those instruments where you file in the United States through your agency and ask for the PCT, and there's a bit of extra paperwork and fees that you need to pay because it is done through an international body. And then you indicate what countries you are looking for protection, and then they take care of doing the filing directly into those other agencies. That's in at a big scheme, and the specifics may change, regulations and what form to fill and what boxes to cross may change from time to time, but that's the overall concept. That doesn't mean that the you're gonna get it approved, just that you are getting filed, just like here in the United States, and then it goes through the normal process that they may have. And overall, it also gives you not so much doing the PCT, but just filing in other places. There are some mechanisms in the United States that allow to accelerate decisions based on results from other jurisdictions. So, for example, if you file in the United States and South Korea approve some of the claims, you could come back with that approval to the US and ask the US to review that claim faster. And and it is basically like a second look. You go to the doctor and you just go to another doctor. So there's a lot of the preliminary work already done. So you get a chance to get approved or review faster. Doesn't guarantee approval. So in a nutshell, are you going to do business there? Then, and it doesn't have to be only the selling, because if you're going to be manufacturing in another place, If you don't have the proper protections, you are open, and even with the proper protections, depending on where you are, they may just go and copy your product or steal your IP, trademarks, copyrights, patents, etc.
Well, that's powerful. And I'm curious, I see members of our audience, so if I may do a shout out to Stephen and to Renee and others. Have you done any work as far as filing patents and had any experience with the PCT?
Directly with the PCT, no. I've done through for trademarks, which is a very similar mechanism. It's just the specifics are different. One of the benefits of the PCT is that they take care of the translations. There are extra fees,
Mhm.
and you need to make the decision. And the same thing, like for example, I had a client that she had a trademark registered in China, and it was for an alcoholic beverage. So there's more than just having the trademark. If you're going to do business there, you need to ship it, etc., etc. You need to have distributors, imports, etc. And I just asked her, hey, do you really need this? Because it's up for renewal in China. It's like, no, it's not worth it. So
Mm.
you need to make the decision on your business. If, for example, very specifically on China, if you're going to be building in China, you probably want to have as many protections, or whatever you're building, you probably want to have as many protections as possible there.
I mean,
Thank you for that, Marcos. I was also pinging Stephen and Renee and asking if they had any PCT stories.
the only ones I can say would be, yeah, in the recruiting, I've looked number of actually projects in the past where I've looked for patent attorneys. So always a difficult search because they're always being sought after.
Yeah.
So, but yeah, for a software company as well as for pharmaceutical company. So uh, they're always in high demand, and then getting into not just the knowing the law, but then also knowing or having familiarity with that particular business. So it's both are important, in fact.
Yeah.
Okay, thank
I don't know if we mentioned that, Chris, but to be a patent attorney, you need to have a degree or certain levels of post-secondary education, certain number of hours of post-secondary education in a technical field. So I had friends and colleagues that it's a little bit crazy, but they had a medical degree. They went to law school, became attorneys, and then took the patent bar, and then they work as patent attorneys basically for companies doing. So there tends to be an area of specialization. I'm an electronics engineer,
Hmm.
uh, so I tend to gravitate toward mechanical patents, which are, fairly standard, and electronics. So if it has to be something about software, depending on how complicated, I may just tell them, hey, go to somebody else. If it is genetics, if it is chemistry, pharmaceutical, medical, then probably there are groups specialized on that.
Hmm.
you.
I mentioned in the chat this was last week about the EU finding
Yeah.
this AliExpress 550 million euros. Um, just more or less a lot of the products that were coming over from China, people were ordering them, and it's like a lot of them were, fake, and you always wonder how much. Um, was the Chinese government aware that they were being faked or being sent or actually cracking down on some of these things as well?
Very well shared. And to amplify Marcos's point, we've had the pleasure of working with several other practitioners who they cover intellectual property, they focus on patents. And it is a significant bar to be able to achieve and pass the patent bar, without saying, whether it's as an attorney, which gives you the advantage of being able to legally represent you in court, or as an agent. that is supporting you before the USPTO. And that plays right into a question I'll ask Marcos to elaborate from his perspective in the audience to consider. Global patent strategy. What's your take on that, Marcos?
You need to consult with your bank account, basically. It sounds very ambitious, and I run into that. I do, in my practice, I may do one patent for every 20 trademarks. But conceptually speaking, are very similar because of and this is what I tell everybody, copyrights, patents, trademarks, and probably trade secrets, all of them follow fairly international standards. Trademarks and patents are very, treaty oriented. So the rules that you could apply, that's why, they allow you some things like you get a patent in South America, in South Korea, or some claims approved, you can bring it as proof here in the United States. Why? Because a lot of the rules follow the same. Implementation is different. Obviously, you got languages, you got technology, you got the forms may be different, but conceptually they are the same. And same thing. I had a client that she had a trademark for capillary surgical implantation machines. So they had their whole portfolio with the patents and everything. And I worked with them on the trademarks. And I think she had like 90 countries. I had a table. And in some cases, we would go, and she didn't go all at once. She said, hey, I want to protect in so many countries, the bigger markets. And then we did, for the most part, we did a treaty, the Madrid Protocol, basically. And it was expensive because it's not only filing, and again, same for patents or trademarks. You gotta pay a filing fee on every country. You may have to pay a treaty fee. You may have to pay for the translations, a bunch of things. But also, if you get some rejection, again, those are not necessarily fatal rejections, but I've been on phone calls with the patent examiners, and I'm thinking he's gonna reject everything, and then after 15-20 minutes he said, well, if you make these changes here and there, I can approve these claims. And I just got to the client and say, guys, let's do this. We get approved, blah blah blah. But that you may have the same scenario in every country where you file, where there's a rejection and then you have to pay a local practitioner. So that's where it can get very complicated. Easily it can be in the hundreds of thousands, if not millions of dollars. And then if you get approved, usually, again, there's a fee for patents throughout the whole thing. You file, you get approved, you need to pay for the registration. Then once you get the registration, you have here in the United States it's 3, 7, and like 11 or 14-year maintenance fee. So there's 3 more fees. And individually, you look at from the American perspective, it's probably not that much money. You're looking at for small companies. They have different graduated fees here in the United States for micro entities, small and large entities. So if you're a micro entity, you may not have to pay that much. But if you want to play globally, it can easily accelerate. So again, just getting one patent here in the United States, depending on how complicated, can start you in the $10,000 range. If it is something complicated like a new drug, you could easily run into $50,000 to $100,000. And if you go and start replicating it around the world, you are into the 6 to 7 figures easily. Also, granted, costs may be much higher here in the United States. Obviously, Labor and professional costs may be different from country to country, but you would expect, developed countries to have higher practitioner fees than others. So maybe cheaper if you get the patent in Mexico or in, I don't know, South Africa or India, but you should expect to pay if you want a patent in Europe. Which brings me just on a little bit of a quick twist. So there are a handful of places in the world where you can get a patent that covers several countries. That's the European Union and also trademark. There's also one region in Africa, two regions in Africa. One is East Africa, and the other one is West Africa. East Africa has like 9 or 10 countries, and the other one also as well, 10, 12 countries. West Africa tends to be French speaking. East Africa tends to be English speaking. So when I was working with this client, we would go and file for the European Union, for example, and we know we had protection in all these places. But
Mhm.
they go and look at every country to make sure that there's no conflict. So
Yeah.
that's the same thing.
One thing with regards to trademark, and this just was announced actually last week. Um, so when you have the seller being fined for selling, like a Louis Vuitton that's not a Louis
Yeah.
Vuitton, or a Rolex that's being Rolex, but now they're starting to enforce people who are buying this stuff. So if you're on vacation, you buy a fake Rolex or buy a fake Louis Vuitton or whatever, um, even if you didn't buy it in the EU or wherever, and they do sometimes look and they say, hey, wait a minute, this is a fake. They will actually find now the people who bought it. So the reason is they want to scare people from buying fakes. So if you're caught buying a fake Rolex or fake Louis Vuitton, you will get heavily fined just as much as if you were selling it.
That's that's kind of a
That came
frightening.
out that came out last week.
Well, Stephen, that sounds like a frightening economic concept from a global trade perspective if you're in one of those markets, because how could you know or reasonably know it
Well,
was a
they
fake?
Price,
it
price.
well price, yeah, one price. If you get a Rolex for like $10 from a guy with a suitcase on Times Square, you probably can guess that's a fake.
That's
Um,
a reasonable part. Yeah.
yeah, that's it. Yeah, and so what they're trying to do is to prevent that. I mean, if you sort of knowingly do that, it just went into effect last week more or less because summer vacation starting, people go, and you see these people on the beaches selling this stuff, and they want to prevent one from encouraging the people who are manufacturing and knowingly breaking the trade law or trade patents, but also to scare people enough. Hey, I don't know if this is real, and I bet if I buy that, I could be fined if I'm caught.
Understood. Thank you for that. Thank you for that share. Transitioning from those shares into our agenda, I just wanted to highlight something related to AI and inventorship. Um,
Yeah.
One of the things that we're seeing in our community and audience are a number of software products, both from major legal services players like LexisNexis and Westlaw, et cetera, but also from startups that are presented to help people pursue patents, from search to prior art and other elements. And there have been, as I mentioned, positions by at least the USPTO on artificial intelligence and inventorship, as well as Copyright Office. But Marcus, do you have any thoughts on the impact of AI from an inventor and operations perspective?
So I'd like to divide, and maybe in the future it will, or it's already getting blurred between the tools for developing a patent. It could be as simple as you know, the Word document that you're using for writing, and then research, the tools that you use for research, and there are databases to using some of those AI tools to draw some conclusions and help you to write the patent. And then the other one, and I think somebody was just trying to pull somebody's leg in there by saying, well, this was invented by AI. It will depend on what it is that you ask them to do. But in general, the consensus is that it needs to be a creation of a human. Now, there's this slight quirk in American uh, patent law, and I'm pretty sure it applies to all countries, where you legally you are obligated to disclose anybody, and by anybody they mean a human, basically that contributed substantially to the invention. Okay, so if you talk to your friend and your friend gives you a lot of good ideas and you implement it in your patent, you should put your friend as a co-inventor. Okay, could that happen with the AI? Maybe, maybe not. So far, the answer is no. If it is a machine, however, and this is a big, big, big thing that we tell everybody: uh, AI, unless you have one of those private agents where you have them isolated, whatever you tell them, whatever you tell the typical Claude or ChatGPT or Gemini, they just bring it back into the cloud and becomes part of their base knowledge. So there is the big risk, and this has been something that has been pointed out there, where whatever you disclose to a ChatGPT or an AI agent becomes public knowledge. And the problem with that is, especially for the filing in the United States and also for PCTs, you have very strict deadlines of if you if I tell you publicly here about an idea that I have limited time to file, um, different levels, provisional, non-provisional, whatever, in the United States, or I lose that opportunity because then it becomes public knowledge, and then something that is widely known by the public cannot be patented. So those are the main things I could envision, and I've been reading a lot about AI, and I play a little bit with some of those things. And there was one guy saying that he created an agent that was just monitoring his conversations, work conversations, I guess, and he was coming up and taking actions on their own. So maybe in the future, not too far, maybe already happening with the right agent and prompts, that he's listening to an engineering conversation and then he just goes out and starts pulling research, doing a synthesis, and then decides to just write a pattern on its own. That could be interesting. I don't think we have, at least the agencies have faced that situation yet, and the ownership there is going to be quite interesting, because how much did the human contribute to that? Maybe they had the conversation, that's where they got the ideas. I don't know, but in general there are the tools for getting the job done, the searches, all that stuff. You could even just ask it to format it and run it and check and everything. As long as it is a tool and the human is using it, the human is the inventor. But we're moving into new territory.
Well,
Just out of curiosity, is it even theoretically possible that if somebody invents something using Claude or whatever, that the owner or that the people who own and run Claude or ChatGPT or whatever could say, well, we actually partially own it because we provided the intelligence to actually do it. Is it
That's
theoretically
a
possible?
that's a very good question. The practical analysis of that, and this is what I tell people: the risk is there, that one, and also just throwing, kind of letting the cats out of the bag, basically. I go to Claude, I ask questions, and the questions are very specific to an invention or a claim that I'm created, and I get a lot of help from Claude, and I use it for a patent. These are the risks that you have, and you identify one, and I mentioned the other one. One is that I'm giving a lot of information that becomes public and becomes part of the repository of Claude. Okay, um, that is the risk. How likely see that that same idea could be picked up by somebody else? Maybe, maybe not. It may depend on how hot that topic is or how arcane it is. If I talk about something very, very complicated, and there is another guy somewhere else investigating the same thing, he's probably going to get my ideas out of there. Okay. But the probability is probably low. It's possible, very low probability. There's a lot of factors. And the same thing, I don't know how much Claude or Gemini are looking at new things in the repositories and see if they can claim any ownership on that. I don't think they are doing that. I don't think it is practical for them. But they may be just running agents trying to harvest ideas for IP, and they may come up with that idea, somebody, and may say, oh, wow, this is good stuff. I don't know if you can, maybe that's a good experiment. If you can send a query or a prompt to one of these agents and said, hey, just tell me, have you been talking to people about creating patents, and what are the best ideas you got? I don't know if they would have some blocking. That's why I said if you're going to do that, maybe do it within a walled environment versus just doing it out in the wild.
And if I may compliment to that, because we use, and we have it in our fee agreements on the law side, on the tech side, we use LLMs. Um, First step is to go to Marcus's point, based on what we know, you definitely don't want to do something related to patent in the free versions because you're giving them options to use your content to train their models. In the paid versions, especially the enterprise versions of products like ChatGPT, you can toggle it off and say, don't train on my data. And so far, some jurisdictions have said if you're using the enterprise version of something like a ChatGPT, you're not sharing data, you arguably are in compliance from protecting client information, just like other
Right.
software, Westlaw, et cetera. It's a different, but it differs by LLM. The same claims not being made publicly by some of the other LLMs that we have that same protection. So it really is a judgment call. And uh, just to give you some sense of the real world implications, we have a number of clients who want to act pro or have acted pro se, and they said they just wanted us to help them just with research. Uh, a lot of them use AI. One's doing data-driven AI for skincare product, company based in Africa and US. Another is using AI for collision detection of human-powered vehicles like bikes, and they've actually registered their patent. And then the third is not AI-driven. They're actually created a game, but in all those cases, they did not knowingly share their information with any LLMs without protecting it by turning off the sharing models and being very careful about which LLMs they use.
Yeah. And if you are going to be using a free version, I would recommend that you kind of, neutralize as much as possible your queries or the information you give them. So instead of giving them a contract where Coca-Cola is licensing the secret formula to X company, just make it like it is a contract between a company, licensing intellectual property, blah, blah, blah. And then, they don't, it doesn't end up in some obscure library in a corner of the internet that you get all this information about, and then somebody maybe in the future can mine it or stumble into that. So I always recommend them, hey, don't tell everything to the AI, just the things that you don't know, and make it as generic and neutral as possible so they don't know what it is at the end of the day.
Outstanding. And now let's get to the what's the phrase, cut to the chase. So we wanted to summarize the question we asked. Now is a good time for inventing and patenting, yes or no? We did some research, segmented it by geographic region, as I mentioned, because of the global nature of the chamber. And in general, the response is yes, it is. And the findings go on to explain why. So I'm going to first start with the exceptions. We looked at North America, South America, Europe, Asia, Africa, and also Australia. Uh, the cautious region was considered to be South America, with indications that some of their technology implementations haven't really eliminated their backlog. So there's a significant consideration of that. But the other markets were yes, in some cases with caveats. And I'm interested in the audience, in Marcos's opinion. Do you agree with these findings? The U.S. claim is yes, it's a good time to patent. AI-driven R&D boom, and the examiners are using these AI tools to be more efficient.
I
For
think there is always, if you got a good idea, it is always a good time to figure out if you can or want to protect it. If you have the means to do that, and there's a lot of good reasons to do a patent, I think. Um, Business wise and protection, we talk about that. It can increase the visibility of your country, of your company reputation, valuation, and ability to raise money if you go that way. And I tell people, as a minimum, it is a good badge of honor for you. It's like, hey, Chris, I have 10 patents or 20 patents on these areas. Uh, it also, you know, depending on the patents last only 20 years, so it's not like it's going to be forever, but depending in you can pass it on to other people, or if somebody's interested on that, you could get some money out of that. So it is always a good time and a good idea to consider, at least. And in some places, like for example in China, that they didn't have a very good reputation on intellectual property, now they are one of the leaders in filings for protection. And that changes the game a little bit, because now they have intellectual property to protect and they don't want other people to violate it. So it makes them hopefully more respectful of other people's intellectual property as well.
Hey, thank you, Marcos. And
Um,
just, uh, excuse me, Steve, I just may mention that um, we've actually, our legal tech venture filed a provisional patent, so we have a year to work out what we think is our invention. And it does have the scaling pricing for it because we believe in general that description North America applies. So, Stephen, please.
yeah, I just say I made a comment at the beginning of this in the chat. If somebody's invented something or thinking of inventing something or with a new idea, would it be advisable before they start going through all the work to use the AI to look through and say, oh, wait a minute, somebody's already got this or that? Because I know before all this, before even Google, it probably was a tedious work to go through, look all over to find out, has this been patented or did somebody have this anywhere else in the world? I'll give you a really simple example. In the US, you've got TJ Maxx, right? We have TK Maxx. The reason being very simple. When TJ Maxx wanted to come to Europe, um, apparently in the UK, I know this because I already spoke with, I know some people who are in the headquarters here in Europe. And because I asked them, are you the same as TJ Maxx? And they said, yes, we are. But when they came to Europe and wanted to expand, there was already a small company in UK with the name TJ Maxx. And they they didn't want to sell it, the name. And so it's TJX. So the corporate name, even in the US now, of the parent company is TJX.
Hmm.
Um, Even with my company, Ames International, there was a company in Canada already calling itself Ames International before we got there, and they wouldn't give it up. So you'll see on our Canadian site, it's North Star, an Ames International company, only for that particular trademark. And, that's one of the things I think that it's like when you're coming up with something new or whatever, it might be worth now with AI to see, hey, before I go through all the investment in the US and I want to expand, is there anywhere else in the world before I start doing this to where it might cause problems down the line?
Yeah, I always tell people to do that for trademarks, even if you're not going to be doing business in other countries, just from the domain names, for example, or the searches. And when it comes to patent, before AI was prevalent, or at least out on the public, I'm sure all these companies were doing AI, different versions of AI behind the curtain. Google launched Google Patents, and it is basically a database that allows you to search globally. And one important thing is a unique distinction with patents is even though you get local protection, US, Europe, etc., you are tested against everybody in the world. So you
Mm,
want to file a patent here in the United States for something, they will look for patents in China, Japan, Korea, Europe, UK, blah, blah, blah. And then they will say, well, you get rejected against, you know, Dmitriev and Levite in patent in Russia, or it could be even any public information. It could be an article, it could be an ad, it could be a product, could be also a patent or even a patent application. So I always tell people, yep, look as broad as possible just to get an idea. The only small drawback is that you need to disclose anything you find that is relevant. So I tell them, yeah, just figure out if there's something like that, and we have to disclose it. But that may help you to try to figure out ways not to go directly face to face with that existing. It's called prior art, you know.
mhm,
That I need to drop in that we've hit our mark, so I'm going to ask, we're going to power through with the responses, which were, is now a good time to invent and patent? And I think the short answer from the data and the research
Yes.
and listening is yes. There are some caveats. There's a lot of money on the table, trillions of dollars in patent value, billions of dollars in licensing revenue. And because of AI and other innovations, it becomes more accessible to a broad audience. So let me open us up for closing remarks. Marcos, any closing remarks to the audience or to the video to share with
Um,
folks?
I tell, I always tell people your intellectual property is probably, in general, is probably the most valuable thing you got. Again, starting from the bottom up or the top down, however you want to look at it. You have trademarks. That's probably going to be the difference between TJ Maxx and TK Maxx, for example.
mm,
And the McDonald's versus Burger King. A burger is a burger, a taco is a taco. The only difference is how you're positioned in the minds of people. And also, you need to have, just in general, you need to have probably the first thing in your in your budget or your plan of business is what intellectual property we have. Maybe just by coming up with the name or the type of business that you have, you are automatically creating something. What do we have? You do your audit. What are we going to be creating over time? What are we, when we need to protect each different piece, and start finding the money to do those protections, basically.
Thank you for that, Marcos. And I'll just summarize by saying there's a lot of money on the table, and there's an accessible opportunity for folks across the economic spectrum to invent and to pursue patents. And I would strongly encourage folks to consider it. Thanks so
Super.
much. Any closing comments before we adjourn, Stephen or Renee?
No, thank you very much. It was very interesting topic.
Outstanding.
Hey, anything
Take
you
care.
need, Steve and Renee.
All
Ciao.
right. Have a good day. Have a good
Thanks.
Happy
weekend.
weekend.
Have a good weekend,
Bye-bye.
everyone. Take care.